Good. Well, good morning, everybody. It is genuinely a real privilege to be here today to talk about product safety before so many leaders, innovators, and practitioners from across the construction sector. Normally, I only get invited to talk to judges or lawyers or arbitrators, so this is genuinely a real thrill for me. And I'm keen to hear from all of you your experiences on the ground later on over the networking sessions. And it's with some trepidation that I follow today in the illustrious footsteps of Paul Morrell, who I know you heard from last year. And having worked so closely with Paul on our review and beyond, I can tell you there is almost no one who knows more about the topic of construction product safety. The good news is that I am equally passionate and opinionated about it. The bad news, however, is that I'm a lawyer, so I'm afraid I'm going to be using more words and less pictures in my slides. More seriously, I come at these issues from the perspective of seeing what can go wrong and with particular knowledge of responsibility and enforcement issues. And since I may not be as well known to this audience as Paul is, I thought I would start by just telling you a little bit more about me and how I came to be standing here today in front of all of you. As I was kindly introduced, I'm first and foremost a barrister, and believe it or not, I've been dealing with civil cases involving construction projects for nearly 30 years. So believe me when I say that I've seen most things that can go wrong on building projects go wrong. And they tend to follow patterns. I have a pretty unique insight into the issues facing the industry because I not only work as a barrister arguing cases for all different types of clients, whatever their role in relation to construction disputes, but I also act as an arbitrator and an adjudicator, which means that I have to decide what the outcome of disputes should be. And that role often requires me to come up with answers to some really difficult questions, and in particular to try and apportion responsibility between the various actors in the chain who may be involved when things have gone wrong. And then, of course, as you all know, I worked with Paul to produce a review of the construction products regime for the government. And what I want to try and do today is to give you the benefit of my experience from these real-life construction disputes, together with some insight from having spent years dealing with the construction products review. And I do mean years. Our original brief when we were asked to do it, Paul and I, in January 2021, was to produce a report within 6 months. As you'll all know, it's now been over 2 years since our report was officially published. And in fact, it's nearly 4 years since we finished the review and provided it to the government. And make of that delay in publishing it by the government what you will. As we stand here today, we still do not have the government's proposed plan for tackling the issues our report raises. That is shameful because the review could not have been clearer in terms of highlighting the systemic issues regarding robustness, transparency and reliability. And that is, putting it at its lowest, a source of great disappointment for Paul and I. But I'm sure an even greater source of frustration for all of you who work in the industry day in and day out. So having been given this platform today, I want to talk not just about what the review said or what the government's failed to do, but to try and look at what industry has done, where the picture is more positive, and to think about what more you might be able to do. And I want to make this a positive message. I want to convey to you that there are genuinely practical steps that each of you can take to assist with ensuring better safety of products in buildings with or without government support. Now, I thought I had to have at least one picture to keep you awake. And when I was preparing this keynote, the movie Groundhog Day immediately came to mind. And I thought of that very infamous line, "It's going to be cold, it's going to be grey, and it's going to last you for the rest of your life." And that's how some of you may feel about some of the issues that have come out, not just from Grenfell, but some of the projects that you've been involved in. And if you've had the misfortune to be involved in construction disputes that reached the stage of involving someone like me, I'm sure you will empathise with that sentiment. I think the key distinguishing feature of construction disputes, as distinct from other cases I deal with as a barrister, are the sheer number of parties who are involved. If you just stand back and think about it, it's often 5 or 6. So you'll have employer, main contractor, subcontractor, architect, fire safety consultant, specialist supplier, manufacturer, and the irrefutable fact is that to date, everyone always blames each other. And post-Grenfell, obviously the proliferation and number of cladding disputes has been truly incredible. Fire safety is now the first allegation in every claim. And if you're a fire safety expert, you're not going to be out of a job for a long time to come. But very sadly, the government's lack of proactive response has also become predictable and repetitive. And just to go back to look at the chronology, I know you will all be very familiar with this, and I'm sure you will have looked at this before, but it's quite shocking when you write it down. Grenfell fire, obviously, June 2017, over 8 years ago. And whatever else people may disagree on, I hope we can all agree it's too long without the government taking clear and decisive action in response. But we are here and we are still waiting for that. And the report that Paul and I produced was obviously not the first nor the last of government reviews, inquiries and consultations to arise out of Grenfell. The government took 2 immediate steps. First of all, to appoint Sir Martin Moore-Bick, who was a retired judge, to chair the Grenfell Tower inquiry. Hearings for phase 1 started June 2018 and then obviously concluded last year. And then secondly, the government appointed Dame Judith Hackett, who was formerly the chair of the Health and Safety Executive, to prepare an independent review on the building safety regulations and fire safety, with a particular focus on high-rise construction. Now, she got to work and with remarkable diligence and efficiency produced her wide-ranging 121-page interim report within just 6 months. That was December 2017. And then her final report, Building a Safer Future, arrived 6 months later in May 2018. And just to remind you, the Hackett report, because it's now quite a long time ago, focused not on the regulation of construction products, but dealt with a wide range of issues relating to building safety. And in particular, it focused on that final stage of the construction supply chain, the responsibility of duty holders in the construction process, including planning, design, sign-off and completion. Now, had also become very clear by the time of the Hackett report, if not before, that combustible cladding had played a critical role in the spread of the Grenfell fire. And so in chapters 7 and 8 of her final report, Dame Judith began the work of interrogating how the construction products regulatory regime could permit a situation in which completely inappropriate cladding materials ended up on a building such as the Grenfell Tower. And she obviously made a number of important and urgent recommendations, including raising the need for a golden thread of product information from manufacture to installation. So her report was a crucial starting point for construction product regulation, but it was clear that what was needed was a more comprehensive review of the regime, which was outside the scope of her review. So some years later, and it wasn't until January 2021, the government thought they might get on with doing something about this. And so Paul and I were appointed to carry out our independent review. And the scope of our review was very broad. We looked at a wide range of aspects of the regime. The key issues included these. Firstly, how we test construction products before permitting them to go on the market, and whether this system could be reformed, expanded, or replaced. Secondly, following on from Dame Judith's work on the golden thread, how we ensure that products which are on the market are accompanied by product information which is accurate and sufficient for duty holders to know what they're purchasing and its appropriate uses. And then third, how any of these proposals would fit in with the UKCA standard mark, which at the time of the review was being proposed to replace the European CE mark for construction products. And as you'll be aware, the government's commitments on this have changed drastically since the review. I'll come back to that. And then finally, we were asked to look at how we enforce the rules that we already have in place, and should any new rules be brought in, to prevent bad actors who do not represent the industry in general continuing to disregard product safety. Originally, it was planned we'd do our report within 6 months. It became clear that the task was much greater than that, so we took 12. We produced our report, signed and delivered it to the government in December 2021. And as I say, it wasn't published by the government until April 2023. Now, a little bit about our report. The process was we spoke to and received contributions from a really wide range of industry stakeholders, manufacturers, construction firms, conformity assessment bodies. Obviously, there was at times some reluctance to talk openly because we were also in the process of the Grenfell inquiry. But gradually, we managed to get the information that we needed and to carry out our detailed review of the current regulatory regime. And what was very striking was the extent to which we discovered many apparent routes of redress that neither of us knew existed, because they're just never used. We discovered there were all kinds of laws that sat there but were just not being enforced. The second thing that really struck us was the complexity and total mess of the system. And thanks to Paul, who bore the brunt of writing the report, he worked on it full time whilst I carried on my other day jobs. The report is, without doubt, thanks to Paul, an extremely detailed exposition of all the confusion, the historical reasons for that, and the problems inherent in the current system, accompanied by some recommendations. And on this slide, I've tried to set out the headline systemic issues we identified with the regime. The report's very long, apologies, but there was a lot to cover. But to give you some of the headlines, one of the key problems that we found was that the UK's product standards are derived from EU law, and in particular the Construction Products Regulation, or CPR, which was came into force in 2011. Now, the problem with the CPR, so far as product safety is concerned, is that it's not directed at safety. It was created to maintain common standards to facilitate the internal market, something that's very important to all of you. And while that doesn't mean that many construction product standards that have been developed won't, in effect, set safety standards, safety is not the driving principle behind the regime. And the most obvious illustration of that was that we discovered that 2/3 of construction products on the UK market lacked any relevant product standard at all, although some were still covered by alternative voluntary technical assessments. And at the time of our review, remarkably, this included products such as internal fire doors and ACM panels, which were obviously present at Grenfell and which acted as conduits for the spread of the fire. We also found, very importantly, that standards designed for market conformity are not designed for systems testing. And that's one of the key problems with this area. And systems testing obviously looks at how the products will interact in different environments and in combination with other products. And that's going to be incredibly important. How that product's deployed in a building will affect whether it works, whether it's safe, whether it's dangerous. And that's something that is very difficult to find people with the skills and capability to assess. And we discovered there was a severe shortage of skills and capacity in the system, which manifested itself in various ways. First of all, lack of relevant skills and knowledge at the design and installation stage, which meant that even with the best designed product standards and conformity assessment system, there was a risk of unsafe installation or combination with other materials or products. Secondly, there was a lack of domestic testing capacity, and that's something the government still hasn't addressed. The 45 CABs accredited by UCAS at the time collectively had nowhere near enough capacity to meet demand for conformity assessment testing. Now, obviously, people have talked about excess capacity in Europe, and at the time we wrote our review, there was obviously the proposal to replace the European CE mark system, which has now been shelved. If we ever get back to that point, we are going to need some kind of transformation in domestic testing capacity. And then finally, we were told time and time again, there's just little confidence in enforcement of the construction products regime. And we were shocked to discover that there had not been a single prosecution relating to the CPR since it was introduced. 2011, not a single one. And a recurring plea in our consultations with the industry was, quotes, try enforcement first. So in short, we found a system not merely under strain, but one which was broken and which required a complete reset. And a few of our key recommendations are also set out on this slide. But in essence, Paul and I tried to set out a roadmap for the government to develop a system which was fit for purpose. And how did we propose that? First of all, to try and fix this huge gap in standards coverage for construction products where no CPR standard had been developed, we proposed a general safety requirement which all products would need to meet. And that obviously is a departure from the underlying conformity-focused principles that underpin the CPR regime. And then for products with existing standards, we proposed identifying certain products as safety critical. And those would need to be subject to additional safety testing, including, crucially, systemic testing. And that was to try and balance safety with the heightened onerousness of systems testing. And then we also sought to build on the work that Dame Judith had started by talking about traceability, product information, and the golden thread. And we recommended a single framework standard for product labelling and to develop protocols for maintaining the golden thread through the supply chain. On enforcement, we wanted better resourcing and publicity of enforcement action. And that, for example, would include having public databases of non-compliant construction products. So what impact did our report have on construction product regulation? To begin with, unfortunately, not a lot. There was a legislative response to Grenfell, as you all know, the Building Safety Act, which was passed in 2022. And that was the government's main response to the Hackett report, rather than building on anything in our report, even though they had our report before that was passed. Again, it was all too difficult, we were told, to go back and start trying to deal with it all at once. Obviously, the main focus of the BSA, in line with Dame Judith's report, is on the safety of high-rise residential buildings and, more widely, the responsibilities of those who design, build and maintain them. As you know, we've got duty holders, broad new legal duties, but they don't extend to those who design, manufacture and distribute construction products. The BSA contains no changes to the CPR and the testing regime. However, it does contain some provisions on construction products to be aware of. It did create a new right to sue manufacturers of construction products, that's section 148, but you have to meet strict conditions. The first is that you have to have a product that is inherently defective, the manufacturer has marketed it in a misleading way, or it doesn't comply with a relevant existing standard. And you'll recall that only a third of construction products are subject to a CPR standard. Secondly, the product has to be installed in a building containing a dwelling, so purely commercial premises won't be affected. And thirdly, the product has to have caused the building to become unfit for habitation. So given the strictness of those requirements, unsurprising, the courts haven't seen a single reported claim under section 148 that I'm aware of yet. Secondly, Schedule 11 to the Act contained a new framework for passing construction safety regulations to supplement the CPR. However, it remains that, just a framework. Until those regulations are passed, Schedule 11 has no effect, and Parliament has yet to pass any. And then the final point on the slide, delayed implementation, possible shelving, as we'll see, of the UK CA mark. When we submitted our report, we had to take it as a given that UK CA will be fully implemented. But of course, last September, the present government has postponed implementation indefinitely, and I'll come back to that. But it isn't all doom and gloom, and I think you can pat yourselves on the back because industry's response has been much more proactive and helpful than the government. One of the first responses was from the CLC. They published a response in August 2024. They were supportive of having safety critical and the general safety requirements. They did caution and say, well, good in principle, how does that work in practice? Paul and I wholeheartedly agree. Our point was to set out the principle and hope others develop the practice, but we're still waiting for the government to take the lead on that. And then secondly, distribution of responsibility in the supply chain. CLC said the government should advise on timescales for secondary legislation. We're still waiting for that. CLC in favour of continued EU alignment, including the new CPR, and also reinforcing the UK's lack of capacity for testing and certification as something that needed addressing. The second thing the industry has done that I think is really helpful is trying to produce voluntary standards and guides. Given the lack of government reaction and responsibility, such initiatives are absolutely crucial. And just to draw attention to a few, there are the codes for construction product information that apply to both manufacturers and merchants and distributors. And they contain the cow-ow principle, so 5 criteria for product information: clear, accurate, up-to-date, accessible, and unambiguous. Certainly good criteria to aspire to. And then very recently, we have the CIOB's Guide to Products Critical to Safety Construction. That was published in August 2025. Again, great example of the industry being responsive, trying to improve itself. Paul and I tried so many times to get this message across to ministers that a partnership with the industry was to be aimed for rather than distrust between government and industry. But this guide's aimed at designers, specifiers and installers, and it sets out to determine whether, or to help you determine whether a product is critical to safety construction, with the aim of assisting in the making of informed product selection decisions. And the guide includes examples and case studies that reference existing standards, including the Code for Construction Product Information. Green paper. Again, I hope that you've all had the chance to look at this. There was a consultation last year from February to May 2025. It sets out how the system might be reformed and endorses many of our recommendations. Fundamentally, it's disappointing, and I would repeat and endorse what Paul has written very eloquently in Construction News. And the problem with it is it's taken them a long time to respond, but there simply is a lack of development of their thinking. It really just repeats a lot of what we said in the review. It contains no coherent, overarching strategy to ensure an effective regime is put in place. Again, I can't go through all of it, but just a few highlights. EU alignment to be maintained for existing standards, including with the new CPR. So it looks like UKCA implementation is being kicked into the long grass. The problem is, it says that, but then it doesn't explain how safety is going to be tackled with EU alignment being maintained. And you can read Paul's frustration in what he's written publicly. The first question he asked ministers every time we met with them was, what are you going to do? And obviously, our review might have said different things if we'd known where we were going to end up. The Green Paper endorses our distinction between safety-critical products and other products, but again doesn't set out where the line is to be drawn. There are important proposals on product information and traceability. There's a commitment to digital product information, potentially leading towards product passports. Manufacturers could be required to supply standardised performance data that could integrate into BIM and the golden thread. And again, clearer rules on marketing, banning selective claims, requiring transparency on failures as well as successes. Enforcement, lots of new ideas, but no development of them. So single construction products regulator, again, new powers for civil and criminal penalties. My point's simple, we don't need more paper. We need this to really work in practice. Again, I've set out there, in essence, asking the right questions. Really, these came from our review, but no answers at all to the key issues. What are we going to do about skills shortage? How are we going to resolve and simplify responsibilities and duties in relation to design, construction, and installation? So just having a look at what you might do. One thing the industry can do is to keep improving those voluntary standards and codes of practice, whether those relate to individual products, a general safety requirement, product information, the golden thread. It's all really, really crucial for industry to carry on developing. The government is never going to give you the answer. They don't know. Second, preempt the blame game with a clear delineation of responsibility. The number one thing that I see in many of the cases that come to me are contracts that do not define clearly roles and responsibilities in relation to construction product selection and installation. I also see a remarkable number of projects where contracts are not in place before work is commenced. And then third, records. I hope digitalisation will help with this. But again, many of the cases I see, the problem is a lack of good records as to what happened. Finally, and I know I'm slightly running over time, but just a few thoughts on trust, and I'm sure we can talk about this a bit more in the panel session. Again, there are lots of things starting to happen, but we need much more backup from government. We need an effective product regulator. We need a massive increase in the amount of testing conducted by that regulator, backed up by a coherent, properly resourced and funded programme of enforcement. And obviously, in terms of public perception, new legislative frameworks are not enough. We need, if there are to be prosecutions over Grenfell, those to happen. Remediation, slow and painful. Only 48% of those high-rise buildings with unsafe cladding have started or completed remediation works. So my message to you today is simple. Decisive government action is key, but ultimately legislation alone will not repair trust, and that's where industry comes in. So over to you. Thank you.